What happens when everyday people find themselves standing before a judge, their futures hanging in the balance? Today, we're stepping inside a real Michigan courtroom for a marathon session that is absolutely packed with drama, tough choices, and jaw-dropping revelations. We've got 7 cases rolling through this courtroom, and let me tell you, not a single one is boring. First up, a man accused of assault and battery who flat out rejects a plea deal and demands a jury trial. Bold move, but is it smart? Then we've got a domestic violence case where the defendant says he's a recovered drug addict. He's been going to NA meetings, he's passed every single drug test, and he's still rolling the dice on a trial. After that, a man who's been driving without a license for 17 years, yeah, you heard that right, 17 years, finally faces the music. But the moment that had our jaws on the floor, a 21-year-old woman who says she had just 1 shot of tequila and 1 margarita and somehow blew a .237 on her blood test. For context, that is nearly 3 times the legal limit. The judge isn't buying her story, and honestly, neither are we. And just when you think it's winding down, we've got a defendant who's mysteriously absent, blaming COVID, and another OWI case where a guy admits to 4 beers and 3 shots and registers a .222. This courtroom session is a masterclass in consequences, second chances, and the moments where people's stories just don't add up. So buckle in. This is going to be one wild ride.
So I'm going to have Mr. Hammond who joins me at the table.
Counsel, we are here for a final pretrial. Is there any resolution?
No, Your Honor. The people did extend an offer of malicious destruction of property under $200 in exchange. They would drop the assault and battery. And with a restitution amount. I've reviewed that with my client. My client has chosen to reject the offer, and he asked that the matter be set for jury trial. Thank you.
All right, Mr. Hammond, I just want to make sure that you understand what happens from here forward. So today's the last day that I would entertain a plea, except that's not true because of the way we've had to adjust trial schedules. So you're going to be set for a trial on May 1st, just so you're aware of that, all right? Okay. But another final pretrial is going to fall in between there. So I'm going to schedule it for the April 23rd final pretrial. No pressure. It's just because we have another final pretrial date. I want to give everybody the opportunity before we end up going to trial on May 1st. Now I think we're up to 3 trials right now, I think on May 1st. So 2 or 3. So as we get closer to that date, the court will make a determination as to what trial goes based on age. So even though you're set for May 1st, it might not be a May 1st trial, just so you're aware of that. Okay. All right. Counsel, is there anything else for the record?
No, thank you.
So you can go to the front window where you checked in and get your next one. Thank you.
Lawrence on behalf of the people. Thank you, Your Honor. Taylor and Anna Frivento on behalf of Mr. Tibs, who joins me at council table.
All right. And we are here for a final pretrial. Is there any resolution to this matter?
There is, Your Honor. The people will be dismissing the charge with prejudice.
Ms. Frivento, I assume you have no issue with that?
No objections. We thank the people.
So, Mr. Tibbs, what that means is the prosecutor is going to dismiss this case and it cannot be brought back. So just as soon as I get that dismissal.
Alright, so let's break down what just happened, because we got 2 very different outcomes back to back. Mr. Hammond was offered a sweet deal. Plead guilty to malicious destruction of property under $200, and the assault and battery charge goes away. That's huge! Assault and battery is a much more serious charge that can carry real jail time. But Hammond says no. He wants his day in court with a jury. Now, that's either a man who truly believes he's innocent and wants to fight, or it's a gamble that could backfire spectacularly. The judge even gives him an extra final pre-trial date on April 23rd as a last chance to reconsider before the May 1st trial. And then there's Mr. Tibbs, whose case gets dismissed entirely. The prosecution just drops it, and the judge makes it crystal clear this cannot be brought back. That man walked out of that courtroom a free man. 2 defendants, 2 completely different paths. One's heading to trial, the other's heading home. What would you do? Take the deal or roll the dice on a jury?
I'll sign that and released from this case. All right, thank you. Court next calls the people of the state of Michigan versus Trey Michael Van Horn, case number 26326 SM. Maris's counsel.
Thank you, Your Honor. Killer and Hannah Defendant on behalf of Mr. Van Horn, who joins me at council table.
And we are here for a final pretrial. Is there any resolution to this matter?
That is correct, Your Honor. The people did extend an offer to my client. Try to count that correctly. Of disorderly jostling in exchange they would drop the domestic violence. My client is rejecting that offer and we ask the matter be set for trial.
All right, so we will schedule this then for the May 1st trial as the original scheduled date. The court has a conflict with now, but because that May 1st trial comes after the next round of final pretrials, we'll also schedule it for another final pretrial on April 23rd. Anything else for the record, counsel?
No. No, Your Honor, thank you.
All right. Excuse me, Mr. Van Horn, just a reminder that your bond conditions continue and you can go out to the front window where you checked in and get your next quote.
So I was wondering, I have a problem with getting up here and like with work and stuff. Would it be okay? Can I get on the blow machine thing instead of having to come up here?
Yeah, so I ordered what, random testing?
Random,
Looks
yes.
like-
I come up in the morning and they do it. You know, I haven't failed any. I have no intentions to fail. I've quit drinking. I'm a recovered drug addict. I go through NA meetings and counseling.
Thank you, Your Honor. Perhaps if the court even be so inclined, could we remove the testing component in consideration of the fact that there haven't been any violations, the underlying charges of domestic violence? It's my understanding these parties have separated and there's been no contact issues at all since this matter was first brought. In the alternative, I've informed my client he can talk to community corrections to see if he could get one of the machines that with him. So he can work in time.
Ms. Lawrence, I know I ordered an alcohol provision. Is there allegations of alcohol use?
Yes, there is, Your Honor. I believe both the defendant and the victim were drinking at the time. Just heard the victim also made numerous statements to our office that alcohol does seem to be a problem with the defendant. So I did still ask for testing.
So I am going to leave the testing requirements where they're at as far as random testing. I believe that's appropriate given the allegations. Or given the allegations. I do realize, Mr. Van Horn, that you have tested 8 times, it looks like, and that you've been negative all 8. But in the grand scheme of things, January 30th wasn't that long ago, based on the allegations. You always have the ability to request one of these SoberLink devices. So there's still time, I believe, if you wanted to go down to the community corrections office and request one of those. They would then put you on the SoberLink device, set up your testing schedule, and then there is a $10 a day fee for that, so you're aware of that.
Yeah.
But that would eliminate the need for you to leave work and come in for testing.
Okay.
All right?
Yeah.
Okay, so you can go out to the front window, you checked in, get your next court date, and then if you choose to, you can go downstairs to request a SoberLink.
Okay.
Okay, there's a lot to unpack with Mr. Van Horn's case. He's facing a domestic violence charge, and the prosecution offered to reduce it to disorderly jostling, which, for those who don't know, is essentially a minor disorderly conduct charge. It would mean no domestic violence conviction on his record. That is a massive difference when it comes to future employment, housing, gun rights, you name it. But Van Horn rejects the deal and wants a trial. Now here's where it gets really interesting. His attorney tries to get the court to remove the random alcohol testing requirement, arguing proving that Van Horn has passed all 8 tests, the parties have separated, and there have been no contact violations. Sounds reasonable, right? But then the prosecutor drops a bombshell. The victim has been telling their office that alcohol is a real problem for Van Horn, and just like that, the judge shuts it down. Testing stays. The judge does offer a compromise though, a SoberLink device. It's basically a portable breathalyzer that lets you test from home instead of driving to the courthouse, but it comes with a $10 a day price tag. So Van Horn is looking at $300 a month just to prove he's sober while he waits for a trial he chose to have. Let me know in the comments, do you think rejecting this plea deal was the right call?
All right.
All right, thank you, sir.
All right. Thank you.
And then second offense notice.
Mr. Shoei, is that an accurate recitation of the plea agreement?
Your Honor, it is. I'm standing in for Jared Shuey. My name is Jerry Faber.
I'm sorry.
P67547. Mr. Smith, do you have any objection to me representing you here today in place of Mr. Shuey?
No, sir.
All right. Mr. Smith, have you heard what the attorney just said the resolution of this case is?
Yes,
And is that how you wish to resolve it?
yes,
Will you please raise your right hand? You solemnly swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth.
yes, sir.
All right, you may put your hand down. So it's my understanding that you'll be pleading guilty to what is essentially an added count 2 of allowing another to operate in violation of the motor vehicle code. That is a misdemeanor punishable by up to 90 days in jail and or a fine of $100. In exchange for that, the people will be dismissing the charged offense in count number 1 of operating while your license is suspended, denied, or revoked as a second or subsequent offender. That is a misdemeanor punishable by up to 1 year and or a fine of $1,000 and possible vehicle mobilization. Is that your understanding of the plea agreement?
Yes, sir.
Back on December 27th, were you on probation or parole?
No.
Were you on bond?
No,
Do you remember reading and signing the advice of rights form in this case to talk about your rights to an attorney and your rights to a trial? Did you understand those rights?
yes,
Most importantly, do you understand that you have a right to a jury trial and that by entering a guilty plea today, you'll be giving up that right and you won't have a trial of any kind?
yes, sir.
Other than the plea agreement, has anybody promised you anything in order to get you to plea?
No, sir.
Has anybody threatened you in any way?
No,
And is it your own free choice to plea today?
yes.
Are counsel aware of any other promises, threats, or inducements not made part of the record?
No.
No, Your Honor.
Then, Mr. Smith, to the allegation that on or about December 27th, 2025 in Cedar Creek Township of Wexford County, how do you plead to added count 2 of allowing another to operate in violation of the motor vehicle code?
Guilty.
In order to accept that plea, I must have you tell me what it is that makes you guilty. I realize it was you driving the vehicle. Were you operating a motor vehicle in Cedar Creek Township back on December 27th?
Yes, sir.
And had your license been suspended at that time?
Yes.
All right. Do counsel believe defendants provided a factual basis in which to accept the plea and the court rules have been complied with?
Yes.
Yes, Your Honor.
All right. Court agrees. I find the plea is knowing, voluntary, and accurate. Mr. Smith, I find you guilty of allowing another to operate in violation of the motor vehicle code pursuant to the plea agreement. Count number 1 of driving while license suspended, denied, or revoked as a second or subsequent is dismissed. Are we able to sentence today?
Yes.
Any allocution?
Yes, Your Honor. Mr. Smith, learned a lesson from this. He is in the process of getting his license back, and I want to thank the prosecutor for the offer because this would have resulted in a 5-year delay to receive that license. He is in the process, and we fully expect that he will be lawfully licensed in the very near future. We are asking that the case be resolved with fines and costs. Thank you.
All right. Thank you. Ms. Lawrence?
I'll just ask for fines and costs. Thank you.
Thank you. Mr. Smith, you have the right to address the court prior to sentencing. Is there anything you'd like me to know?
I am sorry for my actions. I was worried about my wife and now I wasn't thinking clearly. She has medical issues and I was just trying to take care of her. And I'm sorry that I put you guys in this position.
Was there a medical emergency going on at the time?
She wasn't feeling good.
Okay. All right. How long have you been without a license?
17 years.
17 years? You know, it sounds like you're pretty close to getting it back now at this point.
Yes.
Have you gone through the hearing process yet, or?
No, I'm going through the AA and I just started and I got a 27th is as an assessment.
Okay.
All right, this one hits different. Mr. Smith has been driving without a license for 17 years. Let that sink in. 17 years. That means since roughly 2008 or 2009, this man has not had a valid driver's license. And it sounds like the reason traces back to alcohol-related issues, since he's now going through AA and assessment to get it reinstated. Now, the plea deal here is actually really smart lawyering. His attorney got the original charge, driving on a suspended license, as a second or subsequent offender, reduced to allowing another to operate in violation of the motor vehicle code. The defense attorney even thanked the prosecutor, and here's why. That original charge would have added a 5-year delay to getting his license back. 5 more years on top of 17? That would have been devastating. And then Mr. Smith addresses the court and explains he was driving because his wife has medical issues and wasn't feeling well. The judge asks if it was a medical emergency, and Smith kind of hedges. She wasn't feeling good. It's not exactly a life or death situation, but you can hear the sincerity in his voice. Both the prosecution and the defense agreed on fines and costs only, no jail. Sometimes the court system does work in a way that balances accountability with compassion.
And I already got all the letters and everything else filled out.
All right. I will keep this to a fines and costs situation. There is a $75 crime victims rights fund fee, $50 state minimum fee, $150 fine. Nope, I'm sorry, $100 fine, $150 court costs, 0 days jail. Mr. Smith, any balance that remains unpaid for more than 56 days by operation of law has a 20% penalty added to that. So you can go out to the front window where you checked in, get a copy of your judgment, make a payment if you're able to. If not, get set up on a payment plan. Okay, all right, best of luck to you.
Thank you. Thank you.
Thank you.
So the final tally for Mr. Smith, $75 for the Crime Victims' Rights Fund, $50 state minimum fee, $100 in fines, $150 in court costs, and 0 days in jail. That totals $375. Now, for a man who's been driving illegally for 17 years, that is an incredibly lenient outcome. And here's the kicker. If he doesn't pay within 56 days, a 20% penalty gets tacked on automatically. That's an extra $75. So the system gives you a break, but it still expects you to follow through. The judge wished him luck, and honestly, it felt genuine. You can tell this judge is trying to balance the law with real human circumstances. Now, up next, and this is the one you've been waiting for, we've got a 21-year-old woman, a blood alcohol level that defies her story, and a judge who is not going to let it slide. Stay locked in.
Court next call is the people of the state of Michigan versus Jasmine Joe Draper. On Mr. Thomas's case.
I mean, I had the file.
This is case number 26356 SD, appearances counsel.
Warrants on behalf of the people. Honor Taylor and Hannah Tibet on behalf of Ms. Draper, joint counsel table.
Counsel, we are here for a final pretrial. Is there any resolution of this matter?
There is, Your Honor. It's my understanding that the defendant will be pleading guilty to count 2, operating while intoxicated, and operating.
Counsel, because of this printer, I need to make sure that you're speaking up. I'm having a hard time hearing. So it's count 2 and dismiss count 1. Am I correct on that?
Yes.
That is correct, Your Honor.
All right. Ms. Draper, have you heard what the attorneys have said the resolution to this case is?
Yeah.
And is that how you wish to resolve it? I need you to speak up so we can make sure the recording equipment's getting you all right.
Yes.
All right. Will you please raise your right hand? Do you solemnly swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay. So it's my understanding that you'll be pleading guilty to count number 2 of operating while intoxicated. That is a misdemeanor punishable by up to 93 days in jail and or a fine of $100 to $500 and or 360 hours of community service, rehabilitative programs, vehicle mobilization mandatory with a prior, and reimbursements for the cost of prosecution, governmental expenses. In exchange for that, the people will be dismissing count number 1 of operating with a high bodily alcohol content. That carries some of the same penalties as the operating while intoxicated, but it is subject to a misdemeanor of 180 days in jail and or a fine of $200 to $700. Is that your understanding of the plea agreement?
Yes, sir.
Now, do you understand that if this case were to move forward and go to trial, the prosecutor would not be able to try you on both charges? They would have to choose one over the other. Do you understand that?
Yes, sir.
Does that have any impact on your decision to plead? So what I'm asking is, I want to make sure that this is a valid plea and there's not essentially false promises made.
Oh, no.
So the fact that they would only be able to move forward on one of those charges, did that have any influence on your decision to plead today? Ms. Fairventel, do you want to maybe explain it better?
I do understand.
All right. And I want to make sure that you're not entering a guilty plea on the inducement that one of the charges is going to go away, because it would have to go away anyways. Do you understand that?
Now pay close attention to what the judge just did here, because this is really important and shows you how seriously Michigan courts take the validity of a guilty plea. Miss Draper is pleading guilty to operating while intoxicated, and in exchange, the prosecution drops the operating with a high bodily alcohol content charge. Sounds like a deal, right? But here's the thing the judge wants to make absolutely sure she understands. If this went to trial, the prosecution could only try her on one of those two charges anyway. They're essentially the same incident, so the judge is being incredibly careful to ensure that Draper isn't pleading guilty just because she thinks she's getting some huge benefit from having the other charge dropped, when in reality, that charge would have to go away regardless. This is what's called ensuring a knowing and voluntary plea. If the court accepts a guilty plea based on a false inducement, meaning the defendant thought they were getting a deal that isn't really a deal, the whole thing could get thrown out on appeal. The judge even asks her defense attorney to explain it better when Draper seems confused. This is textbook judicial thoroughness, and honestly, every defendant deserves a judge who takes this much care.
Yes, sir.
All right. Back on February 3rd, 2026, were you on probation or parole?
No, sir.
Were you on bond in any other file?
No, sir.
Do you remember reading and signing an advice of rights form talking about your rights to an attorney and your rights to a trial?
Yes.
Ms. Fioravento?
May I approach,
You
Joe?
may.
I've presented Ms. Draper with the advice of rights form signed on February 4th, 2026 from the court's file.
Oh, yeah. Yes,
Do you remember that? Did you understand those rights?
I think so.
All right, I'm gonna go through them with you just to make sure.
Good approach. Thank you.
If you require accommodations to use the court because of disabilities, or if you require a foreign language interpreter to help you fully participate in court proceedings, please contact the court immediately to make those arrangements. Excuse me, do you understand that right?
Yes, sir.
You've been brought to court on a misdemeanor charge and the following basic rights: to plead guilty or not guilty, or to stand mute. If you stand mute, a plea of not guilty will be entered, and you may plead no contest with the permission of the court. To have a trial by jury and to have the assistance of an attorney. Do you understand that? You have the right to an attorney appointed at a public expense if you are indigent, which means without money to hire an attorney, and if the offense charge requires a minimum jail sentence, or the court determines that it might sentence you to jail, the appointing authority will decide if you are indigent and appoint counsel if you are eligible. And Ms. Fioravento has been appointed to represent you. You may have to repay the expense of appointing an attorney, and you may contest your ability to pay the ordered fees if the court attempts to collect any costs for an attorney, and the court must determine your ability to pay at that time. Do you understand that? If you have a trial, you have the following basic rights: to call witnesses to speak for you at trial. You may get an order signed by the court to require witnesses to come to court, to see, hear, and question all witnesses against you, to be a witness for yourself or to remain silent. If you choose not to be a witness on your own behalf, the prosecuting official may not comment on your refusal to testify. And the right to be presumed innocent unless proven guilty beyond a reasonable doubt. Do you understand those rights?
Yes, sir.
If you plead guilty or no contest and your plea is accepted, you'll be giving up those trial rights that we just went through, and you won't have a trial of any kind. Do you understand that? Yes.
Yes.
You also have the right to be released on bond, and that's already been taken care of. If you are now on probation or parole and you enter a plea of guilty or no contest, or a finding of guilt is made by the judge or jury, it may result in a violation of your probation or parole. You can be sentenced to jail and fines plus costs. The court will tell you on the record the name of the offense, the mandatory minimum jail sentence, if any, and the maximum possible penalty for the offense, including jail, fines, or both. Fines, costs, and other financial obligations imposed by the court are due at the time of the assessment, except when the court allows otherwise for good cause shown. If you are not able to pay due to financial hardship, contact the court immediately to request a payment alternative. An appeal to the circuit court must be taken within 21 days from the date of sentence or is permitted pursuant to court rule. If the sentence includes incarceration, and if you wish to file an appeal but are financially unable to retain a lawyer, the court will appoint a lawyer to represent you on appeal if the request for the lawyer is made within 14 days from the date of sentencing. Federal law and or state law may prohibit you from purchasing or possessing ammunition or a firearm, including a rifle, pistol, or revolver. If you are convicted of a misdemeanor crime of violence and you are a current or former spouse, parent, or guardian of the victim, you share a child in common with the victim, you are or were cohabitating with the victim as a spouse, parent, or guardian, or you are or were involved with the victim in another similar relationship. Do you understand all those rights?
Yes, sir.
Do you have any questions for me about those?
I don't think so.
Well, now's your time.
No.
All right.
Thank you,
All right.
Your Honor. I consulted with my client. She has no questions. She is quite young, and this is the first time she has been through this process.
No, I understand. Most importantly, do you understand that you have a right to a jury trial? And that by entering a guilty plea today, you'll be giving up that right and you won't have a trial of any kind.
Yes, sir.
Other than the plea agreement, has anybody promised you anything in order to get you to plea?
No,
Has anybody threatened you in any way? And is your own free choice to plea today? Yes. Are counsel aware of any other promises, threats, or inducements not made part of the record?
No, Your Honor.
No, Your Honor, thank you.
With Ms. Draper, to the allegation that on or about February 3rd, 2026 in Cherry Grove Township of Wexford County, how do you plead to count number 2 of operating motor vehicle while intoxicated?
guilty.
Sure.
Guilty.
All right. In order to accept that plea, I must have you tell me what it is that makes you guilty. So back on February 3rd, were you operating a motor vehicle in Cherry Grove Township?
Yes, sir.
And prior to operating that motor vehicle, had you consumed some alcohol?
Not until I got to the restaurant, and then when I left the restaurant, I was
Okay. So were you driving when you left the restaurant?
attempted to.
You attempted to. So what happened?
I did not do very well, and I went into the ditch.
Okay. Were you driving the car when it went into the ditch?
Yes, sir.
And had you left the restaurant premises?
No, sir.
So you drove into the ditch into the parking lot?
Yeah.
All right. Ms. Lawrence, are there chemical tests to support the plea?
0.237. Let me put that number in perspective for you. The legal limit in Michigan and in every state is 0.08. Jasmine Draper's blood alcohol content was nearly 3 times that limit. At a 0.237, most people experience severe impairment. We're talking confusion, disorientation, difficulty standing, and significant risk of blackout or even alcohol poisoning. And she didn't even make it out of the parking lot. She drove straight into a ditch at the restaurant. Now, her defense attorney mentioned she's only 21 years old, and this is her first offense. Her attorney also pointed out that she was cooperative with the officers on scene, but a 0.237 is not a had a little too much situation. That is a dangerously high level of intoxication. And remember, she hasn't even told her full story to the judge yet about what she claims she drank. That's coming up, and trust me, the judge is going to have some very pointed questions about how 1 shot of tequila and 1 margarita adds up to nearly 3 times the legal limit. This is about to get very interesting.
There was a blood draw and that came back at a 0.237.
Ms. Fiorvento, do you stipulate to its use for purposes of the plea?
Yes, we do, Your Honor.
Do the parties believe the defendants provided a factual basis in which to accept the plea and the court rules been complied with?
Yes.
Yes, Your Honor, we ask the court accept the plea.
The court agrees. I find the plea is knowing, voluntary, and accurate. Ms. Draper, I find you guilty of count number 2 of operating while intoxicated pursuant to the plea agreement. Count number 1 will be dismissed at the time of sentencing. Counsel, I have received a substance use assessment this morning. Due to the law and the court activity, I had the opportunity to review it. Have both of you had a chance to review it?
Yes, Your Honor.
Yes, Your Honor, I've also reviewed it with my client as well.
Are there any additions or corrections we made to it?
I did catch one typo in the recommendation section, Your Honor, or appears to be some sort of typo. It just says prime for life. And so I'm not sure if that's a program that is being recommended. It is just in there between the other recommendations, and that is on page 3 of 3.
I don't know what that means either. Any objection to removing that, Ms. Lawrence?
No, Your
All right. We'll strike that then. Ms. Lawrence, do you have any additions or corrections?
No, Your Honor.
All right. Ms. Fioravento, allocution.
Thank you, Your Honor. This is Ms. Draper's first offense. She is 21 years old, and she's taken responsibility for her conduct here. She was cooperative, it's my understanding, she was cooperative with the officers on the scene. She has not had any issues whatsoever while out on bond in this matter. She has voluntarily attended AA, and she has provided her 30-day tip and proof of attendance, which were sent to the prosecutor. I'm happy to forward those to the court as well. Her substance use assessment indicates that she does not have an ongoing problem, but certainly the events leading to this could warrant some degree of monitoring or probation. This is her pure first offense. She has no criminal history before this. In consideration of all of that, Your Honor, we would respectfully request fines and costs, or if the court would allow simply some short term of probation. She has shown that she is taking this serious through her actions and through her performance on bond and voluntary participation in services. Thank you.
Thank you. Ms. Lawrence?
Thank you, Your Honor. While I do understand her substance use assessment is rather positive, my main concern here is that she is only 21 years old and she's at a 0.237 and she's driving. I do think that is very concerning. I would ask the court to impose a period of probation. I will leave the length up to the discretion of the court. Thank you.
Ms. Draper, you have the right to address the court prior to sentencing. Is there anything you'd like me to know?
I've learned a lot from this so far, and I'm never going to do this again. It costs a lot of money to be here that I don't have. And honestly, now that I've gone to AA and like listen to everybody, I go there a lot. And I think that AA should be in like a classroom in high school or like an after school thing if you want. I think it's just good to go here and listen to everybody's stories and stuff, and maybe it'll help you in the future, like to not to do this or end up in this situation. You know what I mean?
So your assessment says that you first tried alcohol at the age of 18. You're 21 now. Your assessment's coming back that you don't have a disorder. So how often were you consuming alcohol?
Not often. I'd go out once in a while with my buddies. And that was about it.
Okay. The assessment says that you had that you consumed 1 shot of tequila and had 1 margarita. When was that in relationship to you driving your car or attempting to drive your car?
I was probably at the Little Mexico for, I don't know, maybe 20 minutes, and I just slammed on. And then I went to leave because I was in an argument with my boyfriend. I just found out he cheated on me. And so I left. I went to the Little Mexico because that place makes everybody happy. The food's good, drinks are good, you know. And I left there. I was in a little bit of a better mood. So maybe 20 minutes.
How big was the margarita? Because I'm sitting here with a shot of tequila and a margarita to get to a 0.23. It makes me wonder whether there wasn't more there that wasn't reported. I mean, that's,
And there it is. The judge just called it out. 1 shot of tequila and 1 margarita in 20 minutes does not get you to a .237 blood alcohol content. It just doesn't. The math doesn't work. For a 21-year-old woman, even on an empty stomach, 1 shot and 1 margarita would put you somewhere around a .08 to maybe .12, right around the legal limit, not nearly triple it. The judge is clearly skeptical and basically says out loud what everyone in that courtroom is thinking. There had to be more alcohol consumed than what was reported. And Draper insists that was it. Now, she also reveals the emotional backstory. She found out her boyfriend cheated on her, went to Little Mexico restaurant to feel better, slammed her drinks, and then tried to drive. It's a relatable human moment, heartbreak, emotional decision-making, and alcohol. But the judge isn't here for the emotional story right now. He's focused on the numbers, and the numbers don't add up. This is exactly the kind of moment where credibility matters, and it's going to influence how the judge approaches sentencing. Keep watching. The judge isn't done with her yet.
Oh, that was it.
okay. And I did not, looks like when you arraigned, I did not order that you not use recreational marijuana. But I see in the assessment that you used marijuana up until March 1st, which would have been the day before the assessment. Had you continued to use marijuana?
A little bit.
Was that recreationally or medicinal?
Probably recreational.
So this is always something that's fascinating for me, because one thing I'm always concerned with is somebody trading one substance for another. So let me finish. So if you were on a drunk driving charge and you're going to AA, why continue to use the marijuana?
At first, it was like just like help me sleep, and I probably use it once a week, maybe. But I go to AA a lot, and a lot of people are telling me just quit everything, just go to Jesus.
So I am also the sobriety court judge. And I've been on the sobriety court team in different roles as a defense attorney, as prosecutor, and now as judge since 2015 or 16. And I can tell you from my experience, I have to agree with what you're being told. Maybe not the religious aspect of it, because that's individual to everybody, right? But as far as leaving the alcohol and any mind altering substance behind, that's probably your best alternative here. Because what I am afraid of is, like I said, you trading one substance for another. So we start with the presumption in these cases that there's no jail and no probation. But that's a rebuttable presumption. And what I have here is I have somebody who's 21 years old, who is testing without a disorder, but whose bodily alcohol content, in this case, blood alcohol content, was a .237. Didn't make it out of the parking lot. And while stopped using alcohol, and to your credit, you've done everything I would have asked you to do, but we're still using the marijuana. So I want to give you some educational classes and so maybe get you on a path forward where you can put these substances behind you before it does become a problem. And so I do feel that a period of probation is appropriate. It's not going to be a very long period, just kind of enough to get you into the programming and maybe get you grounded a little bit. So I'm going
8 months of probation. Now let's talk about the judge's reasoning here, because it's genuinely insightful and shows you how experienced judges think about these cases. He starts from what's called a rebuttable presumption, meaning that for a first offense OWI in Michigan, the default starting point is no jail and no probation. But that presumption can be overcome based on the facts, and the judge lays out exactly why he's going beyond that baseline. First, she's 21 years old with a blood alcohol content of .237, nearly 3 times the legal limit. Second, she couldn't even get out of a parking lot. Third, and this is the part that clearly tipped the scales, while she stopped drinking and voluntarily went to AA, she continued using marijuana right up until the day before her substance use assessment. The judge raises the concept of substance trading, which is something addiction specialists talk about all the time. It's when someone stops using one substance but replaces it with another. The judge even reveals that he's the sobriety court judge and has been involved in sobriety court since 2015 or 2016 in various roles. This isn't a judge lecturing from an ivory tower. This is someone with deep, hands-on experience in addiction and recovery. And notice how he handles it. Firm, but not harsh. Educational, not punitive. 8 months with the possibility of early release at 4 months if she completes everything. That's a judge who wants to help, not just punish.
To do a period of probation for, I'm going to do 8 months. During that period of time, you're not to violate any law, report is ordered, not leave the state without permission, and to keep your contact and employment information current. Now, this charge does allow you to be released early from probation. So if you've done everything that we've asked you to do at the halfway mark or 4 months, you can be released. Now, if you think you should be, but your probation officer doesn't think you should, you can file a petition on your own. We'll have a hearing and I'll make that determination as to whether or not you should be released. Does that make sense? Yeah. During the period of time that you're on probation, I want you to attend the alcohol highway safety education class and the victim impact panel. Not to consume any alcohol, no illegal controlled substances, including recreational marijuana. And you'll be subject to testing pursuant to the requirements of your probation officer. I also want you to follow the substance use recommendations. I can't, because this is a first, I can't order you into a recovery program, but if you find that beneficial, continue on with that. All right. I'm also going to order any programming for drugs and or alcohol and any additional programming that your probation officer feels is appropriate. Now, what do you do for income?
I work at FedEx.
Okay. Oh, that's right. Part-time, correct?
Yeah.
All right. How many hours a week do you get?
Right now, not very many because Christmas just got over, but we should be picking up in a few weeks. I say right now about 20.
So do you load trucks or what do you do?
Yeah, I load trucks.
All right. How long have you worked there?
About 2 years now. On the 20th, that'd be my 2-year anniversary.
Okay. All right. There will be a $75 crime victims' rights fee, $50 state minimum fee, $150 fine. The court will waive the court costs, attorney fees, Ms. Fioravento.
Waive if the court will allow.
We'll waive the attorney fees. I'm only going to charge you for the 4 months of probation, which is $120. If you end up staying longer than that 4 months, you're going to have to pay the monthly fee for that. Any reimbursements requested, Ms. Lawrence?
Yes, $200 to the Michigan State Police, as well as a $100 prosecutor fee.
In certain cases, law enforcement and prosecutors are able to recoup a portion of the expense in prosecuting these cases, and drunk drivings happen to be one of those. So that's what those 2 fees are for. So there's $100 to the sheriff's department, I'm sorry, $100 to the prosecutor's office and $200 to the state police. 1 day jail with 1 day credit. Because you have sat 1 day jail, you're entitled to $5 back towards that fine. As long as anything I've missed in a judgment of sentence?
No, Your Honor.
Ms. Fioravento?
No, Your Honor, thank you.
Ms. Draper, any balance that remains unpaid for more than 56 days has a 20% penalty added to that, but I'm going to waive that penalty while you're on probation. All right. Do you have any questions for me about your sentence today?
For the educational classes, other than the other than that one, do you have like business cards or a phone number I can call?
So your probation officer will help you get set up for all that. All right. You can go out to the front window where you checked in, get a copy of your judgment, make a payment if you're able. If not, get set up on a payment plan, and then go downstairs to the district court probation office and get signed up for probation. All right. All right. Good luck to you.
Judge, she can turn in her favorite.
She on so Ms. Draper, you can also turn in your SoberLink device to the Community Corrections Office because your testing requirements are going to change as well.
Let's tally up what Miss Draper's evening at Little Mexico ultimately cost her. $75 for the crime victim's rights fee, $50 state minimum fee, $150 fine, $120 for 4 months of probation supervision, $200 reimbursement to the Michigan State Police, $100 to the prosecutor's office, plus 1 day of jail credit, meaning she already sat 1 day when she was arrested, so she gets $5 back on her fine. All in, we're looking at roughly $700 in fines, fees, and costs, plus 8 months of probation where she cannot drink any alcohol, cannot use recreational marijuana, has to attend alcohol highway safety education, a victim impact panel, and is subject to random testing. And notice the judge waived the court costs and attorney fees, and even waived the 20% late payment penalty while she's on probation. For a first offense OWI with a blood alcohol content of 0.237, this is actually a fairly compassionate sentence. The judge clearly wanted to set her up for success, not bury her in financial obligations she can't meet on a part-time warehouse job at FedEx making about 20 hours a week. But make no mistake, if she slips up during those 8 months, it could get a lot worse. Now let's move on to the next cases.
All right,
Thank you so much.
thank you. Mr. Thomas, you're on Vanderwall, is that correct?
Yes, Your Honor, that's me.
All right. Court calls the people of the state of Michigan versus Joanne Lee Vanderwall, case number 254895 SN. Francis Counsel,
Lawrence on behalf of the people.
Isaac Thomas on behalf of the defendant, Your Honor.
Mr. Thomas, I don't see Ms. Vanderwall. Is she present?
Your Honor, I will give some explanation as to that. As the court knows, we adjourned the last final pretrial hearing because Ms. Vanderwall had tested positive for COVID. I believe that was turned into the court as well as proof. If not, I have a copy of that for the file if the court doesn't have it. Ms. Vanderwall called the court yesterday and explained that she still is suffering from COVID symptoms and she's not able to find reliable transportation. And I don't feel I'm breaking client privilege when I say that she informed me of the same, and I asked her to call the court to see if Zoom would be permissible for her to join. I have not heard back from her after that interaction. But if the court feels or would be so inclined as to grant an adjournment for this matter, given the medical reason and the weather issues that have been going on throughout this week, Ms. Vanderwall would very much appreciate it. Thank you.
Did we receive any communication? Did she get a hold of us at all? Ms. Vanderwall, did she get a hold of us at all?
She talked to our staff yesterday, and we just told her to contact her attorney.
It looks like the last time we were here was back on February 26th for a final pretrial. My notes indicate that the defendant appeared by Zoom that day and that she was ill. We set up another final pretrial. Currently residing in Manton and of the snow and ice storm issues. Prosecutor's office, do you have any thoughts?
I would ask for a show cause to the children.
Mr. Thomas, looking through the file, I don't see where there was proof of the prior COVID, but I'll take your word for that. But if you want to submit a copy of it to the court.
But yes, I can present that right now, Your Honor. This is from the initial, so this is from February 26th, is this printout that I'm providing court with. I don't have something that is pertinent to today, but this is the proof that was to be submitted alongside with the initial request for adjournment that we were here a few weeks ago.
All right. we will reset this for another final pretrial then next month.
Thank you, Your Honor. Does the court require that? Oh,
I just made a note in my journal sheet, so you can have that back.
thank you. Would the court like me to submit a copy of this? Okay, thank
No,
you.
that's fine.
Thank you.
Anything else for the record, counsel?
No, thank you.
Nothing, Your Honor. Thank you.
All right, thank you.
All right, so the Vanderwall case is one of those courtroom moments that might seem straightforward on the surface, but there's actually a lot going on underneath. Miss Vanderwall is a no-show. Again. Her attorney explains that she previously tested positive for COVID, which caused the last hearing to be adjourned back on February 26th. Now she's claiming she still has symptoms and can't find reliable transportation. Her attorney even suggested a Zoom appearance but says she never followed up. Here's the thing. The judge notes that the proof of COVID was never actually filed with the court. The attorney doesn't have documentation for today's absence, and this is now the second time this case has been delayed. The defense attorney does his best, citing medical reasons and winter weather conditions, and to the court's credit, they grant the adjournment and reschedule for next month. But you have to wonder, how many times can you delay before the court's patience runs thin? Missing court appearances, even with valid excuses, can eventually lead to a bench warrant. Miss Vanderwall's attorney did the right thing by getting ahead of it and providing what documentation he could, but she's going to need to show up next time. No more excuses.
Court calls the people of the state of Michigan versus Kyle Raymond Fauble. All right, this is case number 26338 SD, appearances counsel.
Courtney Lawrence on behalf of the people.
Jerry Faber on behalf of Mr. Fowle. Good morning, Your Honor.
Good morning. And we are here for a final pretrial. Is there any resolution to this matter?
There is, Your Honor, it's my understanding the defendant will be pleading guilty to count 1, operating while intoxicated. In turn, the people will be dismissing count 2, operating with a high BAC. Additionally, the prosecution is going to be recommending probation.
Mr. Faber?
That is my understanding of the offer. I've discussed it with my client. He wishes to take advantage of that offer.
Mr. Fauble, have you heard what the attorneys have said the resolution of this case is?
Yes, Your Honor.
And is that how you wish to resolve it?
Yes, Your Honor.
Will you please raise your right hand? Do you solemnly swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
So it's my understanding that you'll be pleading guilty to count number 1 of operating while intoxicated. That is a misdemeanor punishable by up to 93 days in jail and or a fine of $100 to $500 and or 360 hours of community service, rehabilitative programs, vehicle mobilization mandatory as prior. In exchange for that, the people will be dismissing count number 2 of operating with a high bodily alcohol content. Is that your understanding of the plea agreement?
Yes, Your Honor.
Now, I want to make sure that you're aware of something, and that's if this case were to move forward to trial, they would not be able to try you both. They would have to choose one over the other. Do you understand that?
Yes, Your Honor.
And did that have any influence on your decision to plea today?
No, Your Honor.
Okay. Back on February 2nd, 2026, were you on probation or parole?
No.
Were you on bond in any other file?
No, Your Honor.
Do you remember reading and signing the advice of rights form talking about your rights to an attorney and your rights to a trial?
Yes, Your Honor.
Did you understand those rights?
Yes, Your Honor.
Most importantly, do you understand that you have the right to a jury trial and that by entering a guilty plea today, you'll be giving up that right and won't have a trial of any kind?
Yes, Your Honor.
Other than the plea agreement, has anybody promised you anything in order to get you to plea today?
No, Your Honor.
Has anybody threatened you in any way?
No, Your Honor.
And is it your own free choice?
Yes, Your Honor.
Are counsel aware of any other promises, threats, or inducements not made part of the record?
No, Your Honor.
No, Your Honor.
Then Mr. Fowle, to the allegation that on or about February 2nd, 2026 in Clam Lake Township of Wexford County, how do you plead to count number 1 of operating while intoxicated?
Guilty.
In order to accept that plea, I must have you tell me what it is that makes you guilty. So back on, I'm sorry, there was another component to this plea agreement that I forgot to mention, and that is that the prosecutor agrees that they would recommend probation. Do you understand that?
Yes, Your Honor.
Now, just because that's their recommendation doesn't mean that I have to follow that. Do you understand that?
Yes, Your Honor.
And as long as they recommend that as the sentence, and I don't follow it, you would not be able to withdraw your plea. Do you understand that?
Yes, Your Honor.
All right. Knowing that added component, you still reassert your guilty plea.
Yes, Your Honor.
So back on February 2nd, 2026, were you operating a motor vehicle in Clam Lake Township of Wexford County?
I'm not sure if it was Clam Lake Township, it was off of South 21 Road. It was 25 Road. It is in Wexford County though.
All right. So you agree you were operating a motor vehicle
Yes,
in
yeah.
Wexford County? And prior to operating that motor vehicle, had you consumed alcohol?
Yes, Your Honor.
Do you remember how much you had to drink? Or what?
Yes, Your Honor. I had about 4 beers and 3 shots of some high proof liquor.
All right. Counselor, are there chemical tests to support the plea?
There is, Your Honor, there was a blood draw and that came back as 0.222.
That's correct. We had no dispute with that figure.
All right. Do counsel believe defendants provided the factual basis in which to accept the plea and that the court rules have been complied with?
Yes.
Yes, Your Honor.
As does the court, I find the plea is knowing, voluntary, and accurate. Mr. Fowle, I find you guilty of operating while intoxicated pursuant to the plea agreement. The operating with a high bodily alcohol content will be dismissed at the time of sentencing. Counsel, do we need to set this for a substance use assessment?
I already had him complete that with Journeys, Your Honor. So we are prepared to proceed with sentencing. I did provide the report in the prosecutor's office with the assessment.
We do not have it.
To apologize, Judge, this is Miss Carey's case that I'm covering. I don't think I have a copy of it.
I don't have
We
a
have a
copy.
physical copy if I.
I don't have a copy. Well, I'm not gonna have time to review that for sentencing now. So what we'll do is we will set this for sentencing and give everybody the appropriate time to review that. All right, Mr. Fowle, you can go out to the front window where you checked in, get your next court date. And then just a reminder that your bond conditions continue, and we should probably be able to get you back on next week for sentencing.
Thank you,
Okay.
Your Honor.
All right,
Very much, Your Honor.
thank you.
And that is a wrap on one incredible day inside a Michigan courtroom. Let's recap everything we just witnessed. We saw 7 cases come through this courtroom, and each one told a completely different story about the choices people make and the consequences that follow. Mr. Hammond rejected a plea deal that would have reduced his assault and battery charge down to malicious destruction of property under $200. He's now heading to a jury trial on May 1st. That's a bold gamble, and only time will tell if it pays off. Mr. Tibs walked away completely free after the prosecution dismissed his case entirely. Trey Michael Van Horn turned down a plea deal on his domestic violence charge, choosing trial over a disorderly jostling plea, all while navigating alcohol testing requirements and the financial burden of a SoberLink device at $10 a day. Mr. Smith, who hadn't had a valid driver's license in 17 years, took a plea deal that likely saved him from another 5-year delay on getting his license back. The judge sentenced him to fines and costs only, no jail time, in what felt like a fair and compassionate outcome for a man trying to take care of his sick wife. Then came the case that stole the show. Jasmine Draper, just 21 years old, with a blood alcohol content of 0.237 after what she claims was a single shot of tequila and 1 margarita. The judge clearly didn't buy that story, and frankly, the science doesn't support it either. She received 8 months of probation with the chance for early release at 4 months, along with mandatory education classes, alcohol and drug testing, and a full prohibition on alcohol and marijuana. The judge's approach was firm but fair, drawing on his years of experience as a sobriety court judge to set her on a path toward genuine recovery. Joanne Lee Vanderwall didn't show up at all, again, citing ongoing COVID symptoms and transportation issues. The court granted another adjournment, but that patience won't last forever. And finally, Kyle Raymond Fauble pleaded guilty to OWY with a .222 blood alcohol content after 4 beers and 3 shots. His sentencing was delayed because the paperwork wasn't in order, pushing it to next week. What stands out across all of these cases is the judge's consistency. Thorough, patient, and deeply knowledgeable about addiction and recovery. Every defendant was treated with respect while being held accountable. That's what justice should look like. So, what do you think? Did these defendants get fair outcomes? Was Jasmine Draper's story about 1 shot and 1 margarita believable? Should Hammond and Van Horn have taken their plea deals? Drop your thoughts in the comments. We want to hear from you. And if you found this courtroom breakdown as eye-opening as we did, make sure to smash that like button, share this video with someone who loves legal drama, and don't forget to subscribe to the channel so you never miss another jaw-dropping courtroom breakdown. We bring you real cases, real consequences, and real insights every single week. Hit that notification bell so you're the first to know when the next one drops. We'll see you in the next one.